So, this idea of agreement. We're spending 2 weeks looking at what agreement is. It's only 1 chapter in your textbook, 1 chapter in your casebook. If we're going to think about it in terms of your reading load, you were asked to look at 2 of each of those for last week, and we barely spoke about them. And this week and next week we're going to spend 2 whole weeks on a much smaller chunk. So why are we doing that? Why are we drilling into that? So this is just the first part of our examination of the jigsaw puzzle pieces. I can't remember if I used this analogy last week or not, but it's really easy to look at this subject and many other of the black letter law subjects as being quite confusing. A lot of what we're doing early on is categorising and pulling apart the various components so that we can understand what a contract is, or what a tort is, or what a criminal act is. So last week we had that sort of big picture view. I'm going to start again with the big picture view, the lid of the jigsaw puzzle box, if you will. Come to in a second. But then we're going to pull out different handfuls. And the first handful that we're going to pull out will be about agreement, which when I learnt it, back in the prehistoric era, we actually thought of it as offer and acceptance as being separate things, but the law has kind of consolidated a bit since. Can you remind me of your name, please? Hi, Mark.
Sorry, Kath. Hi again. Talking about big picture view, this screen is flashing. Can we switch it off in any way?
I have no idea. Why don't you get up and fiddle around with some buttons on that? And please never feel shy about just getting up and doing that sort of stuff. Yeah, it's annoying. I agree. Just have a look. If you can find power supply to it, that will often be the best way. So, where we're starting, I'm going to start with the end in mind at the moment. One of the reasons why you need to be able to identify and understand the various components of what a contract is because you're going to use that information to solve contract law problems. Some of you quite recently did a mentoring exercise in intro. Some of you would have done that last semester or even the semester before, depending on how you're travelling. I think it's been around for 3 semesters now, so if you did intro more than 3 semesters ago, forget that. People who did it with me did a commercial law, in fact a consumer law problem. But I know the problems range from criminal law, tort, range of things. You can tell me what they were in your leisure. But really one of the first things that you had to do with that is actually work out whether or not you even had a legal problem to solve in the first place. In law school, when somebody asks you a question, you've got some immediate clues around you. So if I ask you a question today, there's a little part of your brain that's going, okay, that's Kath, I'm in contract law, we are in week 2, we're doing topic 2. Topic 2 has 2 parts, but this is the beginning of it. Offer and acceptance, possibly a contract question that has something to do with offer. Like, that's not a stupid way to approach it, right? In the real world, a client can come into your space or wherever it is that you meet clients and tell you a story, and you've actually got to work out whether they even have a legal problem or not. For the economists in the room, there is a massive moral hazard when it comes to dealing with clients. That, you know, anybody understand the idea of moral hazard? Any economists in the room? Yay, I can just tell you my version of it and get it wrong and you will not be able to work it out. So, I'm going to use my example. It's International Women's Day, so this is a really bad example, but where I face the biggest moral hazard is when I go and take my car to get serviced. It's like it's a really cheesy, girly problem, but I know nothing about cars, I have no interest in cars, I would rather ride my bike if I could get away with it. If it makes a funny noise, I don't know. And it seems when I take it, the mechanic sits there and, oh, love, oh, could be expensive. It's probably going to take a bit of time, right? I've got no idea, right? That's a moral hazard at the end of the day. He knows significantly more about both my problem and my solution than I do. Similarly, going to the doctor. Anybody been to the doctor and, you go to one GP and they order 57 tests, and you go to a different one and they say, oh, just, take a Panadol, and if you're not better in 2 weeks, come, go for a long walk, or, yeah. Or, again, unless you're actually a doctor, you don't know as much about your problem or your solution. Similarly, people coming to lawyers, they might think they've got a legal problem. Actually, it just turns out that their neighbour is an asshole. Like, you don't actually know. Like, you don't know. So part of what we're doing is trying to skill you up with being able to recognise, is this even a legal problem? If it is a legal problem, what kind of legal problem it is? Like, spoiler alert, the problems that we'll have in this room will be contract problems. Then we've got to look at who might be affected by that problem. We won't get there quite yet, but the concept of privity, who might be affected, who might have a cause of action, is there a cause of action? If there is a contract, then we have a certain cause of action. If there isn't a contract, then we can go in a different direction. So part of what we're doing is just identifying, is there a contract? Now, in advanced contract, you will spend a lot of time working out what cause of action there is. A lot of the questions you get asked in this subject really come down to, is there a contract at all? And then we can ask, if there is a contract, then there's something to sue on. What does that mean? You will not be expected to do that part here. So you won't be calculating damages or thinking about any of that sort of stuff. So a lot of the time we're just working out, is there a contract? So in order to determine whether there is a contract, basically we need to work out whether the elements are there. Anybody want to hazard a guess as to what those elements are? Have you got the mantra yet? Agreement. I heard agreement, and then I heard some offer and acceptance. Consideration. Intention and certainty. Excellent. We will unpick what each of those means. So today we're talking about agreement. Agreement comprises offer and acceptance. Usually, if we've got offer and it has been accepted, then the agreement element has been met, if that acceptance has been communicated. But we can fudge it sometimes. So sometimes there'll be agreement because we can see an agreement. So it's easy when we get offer and acceptance, but not always. So agreement is about asking ourselves whether or not the parties have reached agreement. Agreement is a verb, not a noun. Have the parties reached consensus? Agreement itself is really tied up in some respects with certainty. Okay, because what have they agreed? In order to actually understand if the parties have reached consensus, we need to be able to identify the terms of the agreement or the certainty of the terms. Consideration, and for now we can just think about that as price. It's not price, but that's enough for us to think about it at this stage. Consideration is really around whether the parties have struck a bargain, whether each party has some rights and some obligations. The next really important thing to look at is, did the parties actually intend for this to be a contract? So going back to what we were talking about last week, the kind of working definition of contract or agreement we came up with was something where the rights of parties would be enforced by a court, or the obligation would be required by a court. So sometimes we enter into an agreement where we have a full moral responsibility and absolutely every intention to do what we said we would do, but absolutely no understanding that it would ever be subject to litigation, that a court would ever be involved. And that particularly happens in family or social situations, but it can happen in other situations as well. And then lastly, that certainty piece, again, it is very linked to agreement around whether or not the parties have clearly set out what their rights and responsibilities are. So we need to think each time about what we need to do to create the contract and why we need to know if there's a contract between the parties. So from the point of view of identifying whether we're solving a legal problem. So partly I think because of the way that we study law, we read a lot of cases. And so it's really easy to go straight to who can sue, what would a court say? But most of the time, well, absolutely most of the time, 99.999% of the time that I'm thinking about the legal problem, I'm thinking of it from the point of view of how do I deal with this in the legal documentation? How do we make the contract, not how do I sue on the contract? For every contract that is sued on, there are many, many more that are written. And so actually understanding what the risks are and what the legal requirements are from the point of view of writing the contract is equally important, and I would suggest far more interesting. Is this familiar to you, this idea of Iraq? Get thrown at all the time. We're trying to be really consistent with the models we use. I won't succeed. I don't love Iraq. I think it has a couple of sort of quite major failings in it. I don't think you can get to what the issues are without identifying what the material facts are. And I am yet to meet a client who tells me the important things up front in the right order. So actually working out what the right questions to ask are and what's actually material, I think sits ahead of the issues. So I would call it material facts issues, so MIRAC at best. I don't like the conclusion part by itself either. I like a tentative conclusion at the end, because pretty much, unless you're Justice Keifel and at least 3 other blokes mostly are agreeing with you, essentially you don't know what the law is, that the tricky questions are yet to be resolved. And your job and our role as lawyers is to identify on the balance of probabilities which way we think it would go. I also say that quite seriously as a commercial lawyer, so I work mainly in the technology space, and very few of the kinds of contracts that I work on these days are litigated. If there are disputes, the parties try and resolve them as much as they can without disclosing the terms of those contracts to the wider world. And so we have less and less information about how a court might decide every day, which is really annoying if you're an academic, and quite annoying as a practitioner as well, because you are drawing on your wits and all the rest of it. But I think that conclusion word is a little bit too, I don't know, too conclusive. I would like a tentative conclusion word there. Having said all of that, being able to identify what the issues are, with or without the tools you need to get there, being able to understand which rules apply to which issues, and to be able to apply those rules in a consistent way, to be able to work out which cases make sense, to be able to differentiate on the facts, distinguish on the facts. They are really important things to do. Another tip that I give people all the time is this is also a really great way to take notes about cases. If when you're reading a case, if you are able to summarise what the key issues were, what rules come out of this case or did this case apply, and how did it apply them, what was the conclusion, if you do that consistently, it makes it so much easier to read your own notes as you're going back too, because you've got a kind of methodology for how you've kept your notes. You know, if there's something really interesting in there, like have another section as well, but you can basically, as you build your notes that way, it creates a kind of database for you to come back and find these things. So that's another thing that I think is really useful. So when we're using Iraq, part of what we're doing is we kind of reverse engineer it a little bit. We're going to look at these rules for forming a contract, And you'll be able to reverse back from there to say, okay, these kind of issues all coalesce around rules relating to offer. And these kind of issues, I see them over and over again when we read cases about rules relating to acceptance or the communication of acceptance or whatever. And so you kind of build up your toolkit. That's one of the reasons that we do it this way. This is basically what we're going to do over the next 2 weeks. So really all we're going to do is approach these problems with this kind of flow chart for how we're going to work our way through understanding a problem. So we start with asking ourselves, is there an offer? If there's no offer that can be accepted, we pretty much say, okay, there's no contract, we can stop there. Okay? Not entirely, because we have this consensus idea, but so we may as well start with that analysis. And you'll find, I would be really surprised if we get through all of offer today. It's not going to fit nicely into 1 week of offer and 1 week of acceptance, because we'll need to talk about the acceptance bits as we talk about offer a little bit for it to make sense. And because there's just a lot more law around this. You know, unfortunately, when those ancient judges made law, they didn't do it in nice, neat ways to fit into a 12-week program. So in order to identify what an offer is, and we'll be talking about the use of an objective test here, we actually have to understand what counts as an offer. And we really understand what an offer is as much by looking at things that might look like an offer but haven't been counted as offers in the past. We will need to spend a little bit of time again on this bilateral unilateral contract definition. I wish it wasn't in there because I think it just confuses everybody. They're kind of different things, even though they sound really similar. They're not, it's not like oranges and apples, it's like oranges and puppy dogs. Like, they've got similar sounding names. Well, oranges and puppy dogs clearly don't, but they're about slightly different things. Once we've got an offer, if we think we've got an offer, then the question, one of the questions we need to ask is it on foot at the time it was accepted? Or some conduct that might have been accepted happened. So we need to think about whether it's been revoked or whether it's lapsed or whether it's still in existence. And then after we've dealt with all of that, if we have an offer that hasn't been revoked or hasn't lapsed, is still in existence, then we objectively again look at whether or not their offer might have been accepted. Now, the moment of conception for an agreement is when an offer is accepted and that acceptance is communicated. Okay, so there is a point of time and a place at which agreements are formed. So actually understanding whether acceptance has happened is absolutely crucial to understanding whether or not there is a contract. So we, again, need to, similarly for an offer, we need to understand what constitutes an acceptance. When is conduct an acceptance and when is it something else? I keep using this language that in order for a contract to be made, the acceptance needs to be communicated. So we need to unpick what that means. When or how can acceptance be communicated? Does it matter if the person to whom it was communicated didn't hear it? Does it matter if the person who communicated that acceptance then changed their mind later? When might that matter? When doesn't matter? Does it matter how they did it? If they did it by email or if they did it by post, we get different results. And then also what happens if there's a difference between what was offered and what was accepted, if they're not the same thing, how that works, and how it works when there's a consensus and how it works when it's just a straight out difference. So that's what we're doing. Right, so there is method. Hopefully there'll be some madness too.